Well, good evening, everyone. Thank you so much for joining us tonight. My name is Nicole Cantatori. I'm the head of culture and engagement for Worth Ross Management. So I'd like to welcome you to our July virtual speaker series event. If you are joining us for the first time, welcome. So these exclusive events are designed to bring industry-leading experts to center stage for a unique and uninterrupted experience. So during this session, you'll gain valuable insight, learn about best practices, and have the opportunity to ask questions. Our speakers are selected for the expertise in addressing the needs, challenges, and opportunities faced by association boards and managers. We are recording this session to share with our board members as well as our managers, along with our other webinars that are in this series. And this ensures that the board members will have the resources to lead their communities effectively. So tonight we are pleased to have Teddy Holtz, who is a seasoned attorney with Winstead's Real Estate Development and Investments Practice Group. Today's topic is Corporate Transparency Act, also known as CTA, and we'll be discussing the requirements and penalties. Our format for this evening will include the presentation, and it'll be followed by a 15 to 20-minute QA session. So if you have any questions, please ensure that you type your questions in the chat, and I will be sure to present those questions to Teddy during the Q&A session. So without further ado, Teddy, welcome. I'm going to turn it over to you.
Thank you so much, Nicole. Great intro. And before we actually started this, we were joking about the term seasoned, and I think I've been practicing over 10 years. I think I have to go with that term. It's a great, flattering term, but at the same time, like, ooh, seasoned. Yeah, I don't know about that. Welcome, everyone. Thank you so much for joining. I'll do a brief intro and introduce myself. I'm Teddy Holtz with Winstead's Ready team, and also a member of our HOA practice group. So to tell you a little bit about my background, I'm born and raised, I'm in the Houston area, and been here all my life, save for college at UT Austin and law school in Indiana. So escape that cold, and now I'm wanting to escape the heat. Funny how that works out. I started out as a prosecutor with the Harris County District Attorney's Office, so a lot of jury trials under my belt there. And I made the transition into the Property Owner Association representation field about a decade ago. And that was through a developer client who's developing some subdivisions in San Antonio. From there, I more so transitioned into owner-controlled associations, and that's kind of how I've cut my teeth. And in recent years, since joining Winstead, I have, of course, worked closely with both owner-controlled boards and developer-controlled boards. So kind of get the best of all worlds doing that, and I do enjoy that. A bit about Winstead. It is a big firm under the legal definition, and we have a lot of different practice areas. The real estate section is our most robust, and under that category, of course, we have a HOA subgroup that can handle anything and everything you got. So that is our corporate collection, compliance work. So if your association is in need of legal services, or if you have any questions for me at all, I'm happy to field that. And with no further ado, I think I've covered all that. So let's get into the topic for today. Corporate Transparency Act and POAs. What we're talking about today is federal legislation. So if you are thinking of up and leaving Texas and thinking the nasty CTA will not follow you, unfortunately it will, because it applies to all corporate entities in the country. Let's start here. Okay. So the scope for today, it runs the gamut. We're talking about all sorts of different entities, and really I could be talking about any type of company at the same time, but of course, you are all board directors, officers of your associations, and so I will kind of limit our discussion just to our field and our HOAs, POAs, what have you. So I'm going to be talking about single-family residential associations that are subject to Chapter 209 of the Texas Property Code. Condominium associations subject to chapters 81 and 82 property code, and even our non-209 single-family residential associations and civic clubs. So the only difference there is non-mandatory assessments, or mandatory assessments for some, not all. And then commercial associations as well, and miscellaneous corporate entities. So it really runs the gamut. Every corporate entity has to be knowledgeable, at least knowledgeable of the CTA, and work out whether you need to comply. I'm going to flesh that out here in just a sec. Our agenda for today, what is the Corporate Transparency Act? I'll give you a full spiel on why our legislature came up with it and why we will be having to comply with it. The background and the scope. The definitions of beneficial ownership and substantial control per the Act, those are the two most operative terms, the ones we need to be most mindful of. The penalties for noncompliance, reporting obligations and deadlines, the current status, and what I mean by that, I'll spend a short amount of time talking about not only legal challenges to the CTA, but also how our organization, our trade organization, the Community Associations Institute, has responded to it and what they are doing. So I do think it's pretty important. And then finally, recommendations from an attorney. What would I recommend that you do, and how best for you to work, if Winstead is not your attorney, how best to work with your attorney to ensure compliance. So the Corporate Transparency Act, this was adopted on January 1st of 2021 and passed in Congress in connection with the Anti-Money Laundering Act of 2020. So under the CTA, reporting companies have to provide information about their beneficial owners to the U.S. Department of the Treasury's Financial Crimes Enforcement Network. So a couple things to talk about here. We are in the realm of the federal government. We are, to narrow it down even further, in the executive branch of the government, the Department of the Treasury. And the enforcement network from the Department of the Treasury is FineSyn. So I'll be talking about FineSyn a lot tonight, and exactly what they're going to do with the CTA and what we expect them to do. So why are we talking about the CTA now? This was adopted years ago, so why is this so important now? It's because the deadlines that have already come into being and that will come into being and be triggered here shortly in a matter of 5 or so months. And I will talk about that in a little bit, but it's, the here and the now is kind of why we're talking about it right now. And the information that the CTA is getting at is going to be used to uncover financial crimes, including money laundering, tax fraud, terrorism, and other illicit activities. We all know that HOAs are the #1 funders of terror cells. Hold for a joke, hold for laughter. It's really not. And in fact, I would be so fascinated to know the dollar amounts that have been contributed to terror cells from HOAs. I imagine it's a goose egg, but I don't know. So what entities must report? A reporting company is broadly defined as any corporation, LLC, or other entity created under the laws of any state. Robust, very broad definition. For our purposes, we are in Texas, and what that means for all of us is if our association has been set up with the Secretary of State's office through the filing of formerly articles of incorporation, which are now known as certificates of formation, either or, if they've been filed with the state, that's triggered. It's a corporate entity that's operating and that must report. Certain entities are exempt, including 501c4 entities, and any large operating company with more than 20 full-time U.S. employees, if that entity filed a U.S. tax return in the previous year, reporting more than $5 million in gross receipts or sales. That one's not as important, but probably the biggest exemption, which is why I felt it at least worthwhile to include, just in case you have your own company or you work for a company and you're curious about it. I just want to include that. But for our purposes, 501c4 entities are going to be the biggest one and most applicable to our POAs. Few POAs have gotten that designation. That is something that must be applied for with the IRS. The association has to provide certain information to show that they are a social welfare organization. And that really just means they get a nice little tax break in that designation from the IRS for that same reason. If they have gotten the 501c4 designation, they do not have to report. The directors, officers, the entity itself are not under the purview of the CTA. So we can certainly talk about that a bit more later, but that's the biggest exemption that will apply. If you are at all, curious, or you don't know for certain whether your association has 501c4 status, please consult your attorney. They will be able to tell you absolutely. So beneficial owners. Under the Act, they have defined beneficial ownership as any individual who directly or indirectly exercises substantial control over such reporting company, or owns or controls at least 25% of the ownership interest of such reporting company. Our HOAs, no ownership interest really. It is just a board of directors, also who many times overlap in the officer positions as well. So, a director will also serve as a president, a director will also serve as a secretary, so on. So not too concerned about the, percent ownership interest, but the exercising of substantial control over the reporting company is what implicates our directors and officers. So we'll talk about that right now, because substantial control is our other operative term. And an individual exercises substantial control over a company if that individual serves as a senior officer of the reporting company. That is, again, our president, vice president, secretary, treasurer, even maybe some other titles. Just look to your bylaws and see if there's anything else that may be in the mix there. But if anyone is serving as a director or officer, they are going to have to report. Now, keep in mind, your association may not have that overlap I was describing. You may have someone who is an officer of the association who may not serve as a director. You may have a director who does not serve as an officer. And in either event, doesn't really matter all that much. The director who doesn't have the officer position, the officer doesn't have the director position, they all need to comply, both of them. And that person has authority to appoint or remove senior officers or a majority of the board of directors or similar body, not applicable really to the vast majority of our associations. C, directs, determines, or has substantial influence over important decisions of the reporting company, such as decisions regarding the nature and scope of the company's business, major expenditures, the sale or lease of principal assets, incurrence of significant debt, approval of the company's operating budget, entry into termination of significant contracts, amendments of any of the reporting company's substantial governance documents, etc. I do really like that kind of laundry list they give in the definition, because wow, does that really overlap and apply to a lot of the ongoing business of your association, right? You are oftentimes amending your governing documents to maintain compliance with new legislative updates. You are certainly discussing your vendor contracts and taking bids and deciding and making those important decisions on who you're going to go with for landscaping, pool management, yada, yada. Some debt, sure, so that can certainly happen. And approval of the budget, absolutely. That's a big, big ticket item every year. So I just think it's important to show that they have given us the roadmap and really discern why the directors and officers are those who are in substantial control of the association and why they have to report. So no question about it, our board, our directors, officers are beneficial owners. What about managers? If you are, if you have even a self-managed, none of you do, I wouldn't think, because you're here with Worth Ross, but even someone who is employed directly by an association or has the third-party management company subject to the management agreement, well, of course, the manager is helping you. They can give you preferred vendors. They can even suggest and recommend a vendor to go with if they so choose. So yeah, they're helping you a lot, but there is really no explicit guidance from FinCEN yet. You can certainly visit their websites, and they have a long FAQ section, and I'll even read some excerpts from it later. But what they have not done yet, even though they have some explicit guidance for our POAs, they have not said whether a property manager would be a beneficial owner. So, I mean, certainly the definition of substantial control would lead me to, as a practitioner, kind of leads me to be like, oh, give me that nervous feeling. but I'm going to say probably not. I think there's just a lot of reasons from a policy perspective and from just a regulatory perspective that I don't think the legislature intended for it to be that broad, that sweeping, and have managers also insert themselves and have to report and comply. So I'm saying not no, but certainly, I'm watching this like a hawk for any new developments, any new guidance from FineSense. So if that does change, I will be sure to obviously let Nicole and others at Worth Ross know, and certainly let my own clients know for sure. For reporting obligations, so for the entity, they must provide its name, address, state of formation, and tax ID number. Easy peasy, lemon squeezy there. For the beneficial owner, here's where we get into the brass tacks, because for each beneficial owner, you have to provide your full legal name, date of birth, street address, residential or business, and a driver's license or passport number must be reported. For board members and officers, the residential address is preferable because it will match the address on your driver's license. I think for FineSend, they like that to be neat and tidy. So go with your residential address if you can. An image or scan of an unexpired driver's license or passport must be provided. But all that being said, you can certainly give all that information, take your pictures of your license, passport, send it off to the attorney. I can speak for Winstead in that we are personally okay handling sensitive information. Of course, there's a lot of liability that is entailed there in case there's a data breach, and we're certainly on the hook if your sensitive information is taken from our system. That's a worst case scenario. We don't want that to happen. But I'm just saying this because from our perspective, we are okay shouldering that burden and handling sensitive information to comply with the CTA. However, why I have the FineSend ID option highlighted, much more preferable. It's going to be a little easier process, not only for the beneficial owners, for you to log into FineSend. It's a pretty simple process. I have played around in the system and seen how that plays out. It's really not too cumbersome. You just create a login, and then all the information I just described for the full legal name, date of birth, DL, passport. You will do that on FineSend's site, and they process it and they spit you out a FineSend ID, and all you would have to do then is kick over the FineSend ID to the attorney, and they will get all the information over to FineSend for compliance. So that would be the way better option, just because it doesn't entail your sensitive information going to anyone else but a government entity who already presumably has it, right? So so the reporting entity can provide that FineSend ID in lieu of the personal information. That's the key here. The deadlines I was talking about earlier. Why are we talking about this now and not 2 years ago? It's because we're just coming online with having to comply with these deadlines. There has been things behind the scenes working its way through the legislature and through negotiations. I believe they've already been delayed, but now they're here to stay. There are some more efforts ongoing that I'll talk about, but these are the deadlines in place in the here and the now. And so I certainly want y'all to be knowledgeable of these. So for any corporate entities formed after January 1st of 2024, but before January 1st, 2025, so in this calendar year, they have 90 calendar days to file with FineSend after receiving actual or public notice that the entity's creation or registration is effective. Winstead, we are way heavy on the developer representation. So you can imagine with new developments, new subdivisions, condominiums being built, and the applicable associations being created by the developer, we've already been having to comply with this requirement. So we're well versed in that. And we have those 90 calendar days to do it. Now, entities formed after January 1st, 2025, not as much lenience there because they only have 30 calendar days to provide the required information. So for all our new associations that come online after into the new year, we got to be very, very vigilant there, certainly. Now, why do I have highlighted the next one? Because that's our bread and butter, and that is probably what's going to apply to 99-ish% of your associations. Because entities were probably formed before January 1st of 2024. And until we have until January 1st of 2025 to provide the required information and comply in full with FineSyn, with the CTA. Now, with that being said, status change reports are due within 30 days of a change. What does a change entail? A new director or officer coming into being into the association, whether it be by a natural election at the annual meeting or by appointments due to a resignation, death, yada, yada. So a board member, either their term is up and a new person's coming into an elected position, or a board member is appointed to fill the unexpired term of an outgoing director. And either the date of the annual meeting or the date of the board meeting where that appointment is made by, or maybe even a member meeting, consult your bylaws on that. But a lot of times, especially with newer bylaws and newer associations, the board is given that power to appoint at a regular or special board meeting. So no matter when it happens, 30 days, that 30-day window is kicked into gear. Oh, penalties, my least favorite part of any presentation, because if you're listening to me and I'm doing my job, you're never going to have to worry about the penalties. But, who likes doom and gloom, but at the same time, got to know about them, I guess. So here we go. Could face civil or criminal penalties if any person, I'm going to skip down because that person definition is very important, includes any individual, reporting company, or entities. So we are talking about repercussions not only for our beneficial owners, our directors and officers who have to comply. We are talking about the association itself. And so keep that in mind. It's important for some stuff I will bring up later. And so if any person willfully provides or attempts to provide false or fraudulent information, or they willfully fail to report complete or updated information to FineSyn, they can be held liable. Now, I told you about my prosecuting days in the past. So I am putting on my criminal law hat with this one because willfully is a very operative term. What we talk about in criminal law is the mens rea of a crime. That's always at play because it depends on what the crime is. If it's a murder charge, there has to be an intentional aspect to it usually. And so the way it would, a charge would read is, this person intentionally killed someone or intentionally provided or attempted to provide false or fraudulent information. Intentionally and willfully, I think, are exactly the same thing. And so there does need to be that, mental component to this. What was the state of mind of the person or the reporting company in not complying with the CTA? And I think all this is to say, I am in the doom and gloom aspect of the presentation, but it makes me sleep a little easier at night knowing that this is a very weighty burden for the government to meet, to show a willful failure to comply. So it's something that, as far as my clients go, I want to stress that, because certainly you got to comply. There's no wiggle room there, but at the same time, not going to be too cumbersome if the government, Uncle Sam comes knocking, I'll put it that way. So the civil penalty, it can be up to $500 per day, and for each day that a person continues until a violation is remedied. The criminal penalty is a fine of up to $10,000 and/or imprisonment of up to 2 years. No one wants to go to the slammer, so yeah. And the safe harbor, another protection for all of us and our associations. If the person acting in good faith corrects inaccurate information submitted to FineSyn within 90 days of the inaccurate report, they get a reprieve. So that's good. But what I don't see here, and I don't see guidance from FineSyn on, is the situation where an association or a director or officer is ignorant of the requirement, does not know about the CTA. Do they get a pass, or do they get the safe harbor protection? It doesn't look like it to me, not from the way the CTA reads, and certainly not right now. But what I think about this is if there is that ignorance component of just, I don't know about this law, I didn't know I had to comply, I didn't know I had to give all this information to the government, then I think we go back up to our mental, the mental state aspect of it. There was no willful um, part on anyone to, skirt the government's requirements here. So I think, again, it's a nice place to say we can sleep a little easier knowing we have these protections. But at the end of the day, got to comply. So the current status, I do have a little bit to say about this. Don't want to go too far into it just because this is ever changing and evolving. But I think it's important to show, exactly what's happened to date and the efforts that are out there that are being advocated on behalf of associations nationwide. So first off, in early March of this year, a federal lawsuit of the U.S. District Court of Alabama, Northeastern Division, declared the CTA unconstitutional, but only as to the parties in the case. So that ruling has been appealed to the 11th Circuit Court of Appeals. And I want to stress here, because you may be saying, that's Alabama. Why would that, apply nationwide? If you are a student of either the law or of politics, there's been a lot of news lately about, venue shopping in the federal courts. There are some federal courts that, certain plaintiffs will actively and choose to file in their jurisdictions.
Teddy,
To
I
get,
apologize for interrupting you, but you're cutting out just slightly. It sounds very
I don't have to
staticky.
worry about that.
Yeah, it's a little
Yeah,
bit
and
staticky. I
that
don't
is
know
why I
if you
worried
have a
about.
headset or anything. Do you have a headset or anything?
No, I don't.
Okay.
Um, let's just keep going. I mean, is it completely unintelligible?
Yeah, it's getting worse by the moment. Do you want to log off and hop right back on?
I can try that,
Maybe
yeah.
you should try that just to see. It could be a connection that got bad. So sorry. Apologize for the delay, everyone. Little technical difficulty. Never a dull moment in a meeting when you have technical difficulty, right? Hopefully that fixes the issue with them hopping off and hopping back on. We shall see. This is just a little reminder. Thank you all for the lot of engagement in the chat. I appreciate that. There's questions that you have, feel free to type those questions and we'll make sure we'll get to those questions during the Q&A. Exactly, Brian.
Is it better?
Absolutely, sir.
Woo,
Thank you
okay,
so
I'm glad.
much.
Okay,
Absolutely.
if you
And you
want to
can
be a little
you're
faster,
and that
close it out at
happens
the end.
sometime, hop off right back on and then you can go ahead and turn your camera back on too.
Oh, I didn't know that was off. Sorry.
And if that could be the culprit, we'll find out. If that's the case, we'll turn it off and see if that fixes it. Thank you so much.
Okay, it looks like it's on for me. Can you see me?
I can see you. It's great and you sound great.
Oh, perfect. Okay, I'm
Perfect.
gonna launch right back in. So,
Thank you.
well, I was talking about venue shopping, and there are those cases that come out to where a judge will declare something unconstitutional, or some sort of executive action unconstitutional, and completely change it for the entire country, right? But it's just maybe one district in Alabama, Texas, whatever it's going to be. So this did have the effect of rendering the whole thing unconstitutional, but they limited their holding to just the parties in the case. In response to the ruling, Feinstein stated that expects all other corporate entities to comply with the CTA, so they doubled down. And then Feinstein reinforced the reporting requirement for POAs. I mean, they're getting serious. They wanted absolutely for POAs to know you're not getting out of this, no loosey-goosiness here. And then what are other litigation and lobbying efforts that are happening? So I mentioned earlier our trade organization, Community Associations Institute. It does have national, state, and local chapters. And if you're not already aware of that, but at the national level, they have already indicated their intent. I believe the board voted, and they will be filing a lawsuit against the government to either get some reprieve from the reporting requirements that we've discussed, or to get delays in the deadlines, the reporting deadlines that I already went over. So just have to wait and see there. But With all that being said, the takeaway here, this is all unsettled. Legal challenges, it can take years and years to play out. And in fact, as we're seeing, something that has been in place and precedent for so long can change on a dime. So we just all have to be aware of, what the new changes are and what's going to happen. Nevertheless, I'm not here to give you false hope or tell you that the deadlines absolutely will change and that maybe you don't have to comply. I've told all my clients, I'm going to tell all of you on this presentation, I want you to comply in short order. It's just safer. I don't want you to mess around and knock up against the January 1st deadline in any way, because we just don't know how the government's going to respond in these early days. Okay, I wanted to read from FinCEN the FAQs that I was mentioning earlier. They laid it right out there. What's a frequently asked question? Are HOAs reporting companies? They gave the attorney answer. How dare them? It depends. Homeowners associations can take different forms. As with any entity, if an HOA was not created by the filing of a document with the Secretary of State or similar office, then it is not a domestic reporting company. But for our purposes, as I said earlier, you're pretty much all set up through articles of incorporation or certain information with the Secretary of State. So yeah, we're good there. So an incorporated HOA or other HOA that was created by such a filing may also qualify for an exemption from the reporting requirements. For example, HOAs recognized by the IRS as Section 501c4, social welfare organizations may qualify for the exemption. An incorporated HOA that is not a 501c4 organization may fall within the reporting company definition and therefore be required to report beneficial ownership information to FinCEN. That's the vast majority of our associations, unfortunately. So yes, no wiggle room there. I just put that June 10th date because that is the date that is current as of that date. They have changed it just a hair from the previous one I saw, but just be sure to keep, my job certainly to keep informed of any changes there. So I'll get that information to Worth Ross if it happens. Now, I want to include this next one because it shows you how strict Uncle Sam wants to be with the CTA, because here's what they're saying now. If a reporting company continued to exist as a legal entity for any period of time on or after January 1st, 2024, in other words, did not entirely complete the process of formally and irrevocably dissolving before January 1st, then it is required to report its BOI to FinCEN, even if the company had wound up its affairs and ceased conducting business. It will happen every so often, as in my line of work. I will have a manager, I will have a board member come to me and say, you know what, I think this association, they were operating for some time, and I don't know, we just kind of lost track and didn't hold annual meetings for a number of years. I don't know, I don't know what's going on with it. Well, my fear here is, my goodness, someone's going to be on the hook if you don't know that it may no longer be operating, but it wasn't ever formally dissolved. Then they're saying, yep, you need to report. So I just think that's so strict. I don't know if that will hold water down the line, but the message I can reiterate that I said earlier, this is all just up in the air, and we all kind of have to keep abreast of any developments here. The biggest question, what can the association's attorney do? I know I got with all of my clients January 1st and 2nd. I was working furiously to get my emails out and tell you exactly how you need to comply. And I will do so. I will have my October follow-up, my tisk, have you done it yet email. That's all in place. And it's a sad, sad truth. Not all attorneys can be me. I'm just kidding. No, I hate tooting my horn. I told Nicole earlier, I hate tooting my horn. I do. But that's my joke. So associations, if you're not me, if you haven't gotten that email, then what the attorney should be doing is contacting you directly to inform of the obligations and seek the return of your information, that BOI or your FinCEN IDs. Those are preferable. If you haven't heard from your attorney, reach out. Now's about the time to do it. and make sure that, because they may feel a little differently than Winstead, they may not want your personal information, and I would want to know that sort of stuff. They're probably okay with the Feinstein ID, but just, yeah, maybe not all attorneys are going to be okay with that. So what if the director or officer is unwilling to provide the information or obtain a Feinstein ID? Well, that's a problem, isn't it? Because not only is it liability for that individual director or officer, it's liability for the association, entailing civil and criminal liability. And that can't happen. I mean, as a practitioner, I say, no, no, no. We got to do something about that to prevent the liability to the association. And what I mean here, and I'll put it this way, I actually watched that Charlie's Angels movie from 2000. I was wanting a popcorn flick. It worked out. It's a good movie. I liked it. Well, yeah. But the villain's plot in that one is, oh my goodness, this private company is going to have all our data, and maybe the government's going to have all our data, and it'll be the end of privacy. But the one of them says that, and I'm like, oh, that came to pass in short order. that all went kaput like a decade later. But there are still those folks who, I guess, have the Nokia phones and the flip phones and do not want the government to have any information. But hopefully they're few and far between. But we do need to be primed for that, because if they're coming into place, we need something in our back pocket to use. And where that comes into play is a compliance policy, a CTA reporting compliance policy, can be drafted that calls for the automatic removal of any director or officer who fails to provide the information that the association would need in order to comply with its obligations. So the policy that Winstead has come up with, it acts as both a policy and a supplement to the bylaws. I think just by saying that, I can hear maybe the screams out in the in the universe of, my goodness, how does that work? Our bylaws can only be changed by the members. It can only, we have to go through so many hurdles and jump through all of them, jump through the hoops to get a bylaw amendment passed, and it's not even worth it. Well, there are the workarounds. I mean, I'm going to just reference them. I'm not going to go into full detail, but if you're a condo association, it says, unless the declaration provides otherwise, the board can adopt and amend bylaws. So that's a statutory override. It can be. There's also in the Biz Org Code a statutory override. If it's in their certificate of formation, or if the members have expressly provided otherwise, then the board can do it. So I'm really just saying that for the purpose of, it's almost too important, just from a liability perspective. I would worry more about a challenge to the policy and the way the board implemented it than I would about, the actual liability that's entailed for someone not getting off the board for, not reporting to Feinstein. So, yeah, we'll see how, again, like I said, a lot of this is unsettled. That will also be unsettled and could be subject to a challenge, but hopefully, it holds water at the end of the day. We think it will. So in more detail, what does that policy entail? For new board members and officers, it gives them 20 days to register and comply. Again, that's from the date of their election at the annual meeting, or their appointments at a board meeting or a member meeting. So we have that 20 days. Keep in mind the status change deadline I mentioned earlier is 30 days. So still well within, we have 10 more days to go before it becomes a problem, right? So upon failure to timely register and comply, that board member is considered immediately ineligible to serve on the board or as an officer and is removed from that position. But we give them an automatic reinstatement if registration or compliance is achieved within 15 days of the aforementioned deadline. I mean, again, we're going over the 30 days by 5 days only, but I don't think Uncle Sam will come snooping at day 31 for any association. I don't think, and really what needs to be explicitly said, what I've been dancing around this whole time is, the policy reasons for the CTA, of course, the government's head is in the right place. Who likes financial crimes? No one. But did they really mean for this to apply to our nonprofit HOAs? I don't know. And I mean, they're certainly doubling down and saying yes. And certainly there are financial crimes that occur in our HOAs, as unfortunate as that is. But there are other methods. That's kind of what we're saying. There are other methods within the criminal law and within statutes to address that as opposed to going through a new regulatory framework with CTA. So following the removal and after the reinstatement period expires, the remaining directors choose the successor to fill the unexpired term or vacant directorship or officer position at a special board meeting. So again, that could conflict with a appointments provision in your bylaws as written, but to my earlier point, a little more important to shield the association from liability from a bad actor like this. All right, I'm donezo. So ensuring compliance with the CTA as soon as possible is going to be to your benefit. That is the one message I want you to take home with you and take to heart, because now's the time. We're just, I mean, time is going just at a rapid. I mean, each year we we grow a little older and time just seems to slip on by. So we'll be in November, December territory in no time, and we'll be saying, "Oh goodness, we got to comply." So just better to do it now and not have to worry about it. And be sure to maintain that compliance by timely filing status change reports after a change in directorship or officer position. That's something that the attorney and the management company will certainly be mindful of, and will just make it our new standard operating procedure and something that we'll let every board know when that happens. And then consider adoption of a CTA compliance policy. I'm not saying your individual attorney, if it's not Winstead, has something like that they thought of, but I do think it's something, a discussion you should have with your attorney, because they may have their own safeguards, a similar type of policy in place, but we feel that's the best way to shield your association from liability. Absolutely. All right. Me from a couple years ago. You know what I already look like.
A lot of information. We do have some questions that have arose. So we have about 4 so far, and I'll keep monitoring. So the first one is this is kind of clarification. And for the new associations formed after January 1st, 2024, that applies to the date their articles of incorporation certificate of formation is filed with the state, correct?
Yes, and to get even more technical, when the filing is accepted, it's usually pretty instantaneous. I think with the Secretary of State, they're very, very quick when it comes to that. So it's almost same day, if not the day after.
Excellent. Hopefully that answered your question. If not, feel free to type in a follow-up question. Thank you, Teddy. The next one is, are days to register or comply calendar days or business days?
Calendar days.
Excellent. Next question is, is there like an official link that you have? I thought I did see this for to register or to create your FinCEN account, your ID.
Yes, and Nicole, I think maybe best, I should have my presentation, tisk on me, but how about this? I will email you the link, and that can be emailed out to everyone on the presentation.
Okay, that's wonderful. I thought you had it embedded in the presentation, actually. There is a link I thought for sure. And that may be the easiest way, and then I can share the presentation. So that I thought for sure you did have a link there, maybe not, but that may be the easiest way.
And maybe there's like draft number 9. So
yeah, maybe it was removed, but I think that would be the best way is to make sure we embed it there, and that'll be easy access to everything's in one place.
Yes, so I will send you the presentation with a link.
Yeah. That sounds fantastic. Perfect. Excellent. The next question, is there a method to unregister at the end of the board member's term, or is that not needed?
Not needed. That's a very good question, though. And I think the way this plays out, and this was actually asked in a presentation, I did this presentation just yesterday, actually, too. They asked, do you only need one FinCEN ID? Like, let's say you get off on the board of your HOA, maybe you move into a new subdivision or condo, and you join the board of that association. I think the FinCEN ID follows you. I think it's unique to you. It never goes away. So there is no need to retract it. I think that will be I think at the time of the status change report is when that will happen. The status change will say this person's going off, this person's going on. So simple
Okay,
enough. Mhm.
excellent. Another question just popped in. Did I read it correctly that businesses with 20 plus employees and 5 million plus in revenue don't have to comply? So this only targets smaller corporations.
Yeah, and I don't get it. I don't get why the government has that carve out for a big company like that. I guess they think there's more internal, more people looking at the books, more people who will prevent that sort of stuff from happening. So yeah, it does seem strange to me, but for our purposes, it's, I really just want to put it out there just for, your own knowledge. If it's going to obviously pertain to your company or a company you work for. But for us, it's really just that 501(c)(4). That's the biggest exemption we'll get for our associations, if you can get it.
Okay, thank you. Another question was added. Most management companies have some form of indemnity provision in a contract for management. Would that
Mhm.
remove the substantial influence and therefore reporting requirement of an individual manager or employee?
Ooh, that's interesting. So we're going back to that question I'm posing. I really don't even have an answer for it, but the question I posed of whether a manager
Mm,
has to provide and register with FineSyn to comply with the CTA. So at this time, I'm saying no. And I think management agreements, I think that's an interesting topic too, whether there needs to be some tweaking of that and whether management companies will tweak their agreements to address the CTA. I don't necessarily know how that's going to play out or the details on that, but suffice to say, for your purposes as a director and officer, there's no, wiggle room. There's no shifting of the liability or burden onto the management company or vice versa, because the HOA itself is implicated and liable, and the individual is liable. I think it's best. I think I answered the question. But if not, please, I can clarify maybe.
okay. I'll see if there's any responses. There's another question. If you serve on two HOAs, do you have to report
Mhm.
twice?
Absolutely. Yeah, Uncle Sam wants to know what you're up to. So if you're serving on the board for two associations, and my hats off to you if you are, they absolutely will want to know and have you register through FineSim.
Thank you so much. So there is a couple of comments. I'm just going to talk through the comments so we can, and maybe you can
Yeah,
answer this because it looks like there's some responses. Thank you for responding, Katrina. So there's a comment that come up, is additional provided by WRMC, which is our management company, um, or we on our own at this point? Are we on our own at this point? So the comment was the management company would not, because the board is making the decisions and the management um, company is just carrying out those decisions. So is that correct? We want to clarify that.
yeah, and I mean that of course can be written into the management agreements. A manager can technically, like, I'll just give an example. Like if there's an emergency in a condominium association, a lot of times it will be written in that the manager can make a decision in an emergency up to a certain dollar threshold, right? I don't think that's enough, again, to move the needle to get us to a place where managers have to comply with the CTA. But I just hate to keep saying this, but I just don't know for sure. Feinstein has not given us that guidance. And I think it's going to be an open question until either they directly answer it, or, we don't want to be the first, to ever find out, but someone may have to find out through the legal process.
All right. I don't see any other questions that are coming up right now. You seem to have kind of gone through these. We may give everybody just a few more minutes. Um,
Sure.
is there anything else, Teddy, that you can think of since you've presented this presentation? Other questions that may have been asked during other presentations that have not yet been asked here? It'll just be some great information for the attendees to have.
No, Yeah, I mean, I'm thinking of the Q&A from yesterday. I think I referenced a good one that was asked, but no, can't really think of anything else at this time. Um, Really, just the kind of biggest things to stress with the Q&A is, I wish I could give you direct answers for a lot of this stuff, but like I said, it's so up in the air with a lot of it. We just don't have, like with any legislation like this, the way it gets interpreted and um, you know, morphs over time is through the legal process and through changes that the legislature makes to them. One thing I want to note too, this wasn't asked, but I think it's kind of an important consideration, is that the Chevron doctrine, the Chevron deference that has been in place since the 80s, was recently overturned by the Supreme Court. Now, I do not know how this will affect the CTA and whether this will have any, major effects. But what that decision did is, back in the 80s, the Supreme Court authorized federal regulatory bodies to interpret legislation, to interpret statutes. So one example would be like the FDA can determine how many polymers make up something, how do you get, dish soap? How many polymers go into that? And certainly a judge, may not be the best equipped to handle that, is what the thinking was back then. And now the Supreme Court has shifted that back to the judiciary, right? So they want judges to make those decisions again. And I think I'm really just saying this because it may strip a lot of this power away from Feinstein in making these sorts of regulatory determinations, what does comply with the CTA, what doesn't, and may shift it over to judges to make those decisions. There's just something, just food for thought more than anything else at this point, and way, way unsettled there, because that just happened about a month or so ago.
Okay, there's another question that popped up. Do committees, either with or without an expenditure budget, constitute substantial influence and require reporting?
Oh, I'm so glad you asked that. That was a great question from yesterday too. So yes, there are some committees that make decisions, right? An ACC, ARC will make a decision on an architectural application. Um, and that is a decision, right? But I don't think decisions like that move the needle for Feinstein. I think it is, remember, we're thinking about the association itself. Now, if you set up a committee as its own individual corporate entity, that may have to comply. You may be in trouble there because you have a certificate of formation, you have your articles of incorporation. But the way this usually plays out is that most committees, even with the budget, do not make the meaningful enough decisions to where they will implicate themselves and have to report. The board, the buck stops with the board, right? The board can oftentimes appoint members to those committees, take people off of those committees if they so choose, and even make determinations on a budget for the committee. So really the point here is that the board they are the decision makers. They are the ones who are absolutely, fall in line with the definition. I think if you are serving on a committee, it's going to be way tougher and, again, probably unanticipated and unknown by the legislature that those folks would be subject to the CTA.
Yeah, that's a very good question.
Mhm.
Okay, at this time, I don't see any other questions that have popped up. I think everybody's had some time to kind of think of what other questions would pop up. So, with that being said, it's only 5 minutes remaining. I say that we can end this session. Teddy, thank you so much for taking the time to be here to walk us through and have a better understanding. This recording will be available once it's uploaded to our YouTube channel. I will be sure to get the information out via email to our current board members as well as to our applicable team members. So that should be over the next 48 hours. Thank you so much again, Teddy. Thank you everyone for joining us tonight. We hope that you have a wonderful evening.
Thank you, everyone. And just as a reminder, Nicole, I will get you that link that can then be shared, and everyone can start playing with Feinstein. as fun as that
Fantastic.
is. Hmm.